Good afternoon to all of you, my esteemed panel, which includes my dear brother, Justice Hemant Gupta. Let me first congratulate Pratibha Jain as well as Professor Rajkumar for organizing such a not only important event, but I have seen the contents of the various sessions and the way it has been planned and articulated. I really admire. I have always been an admirer of Professor Rajkumar. He has been a great professor, no doubt about it, but his talent along with Pratibha Jain is now very apparent in this event. For the last 2 days, you have been discussing about glocalized world. So this session is devoted to future of international arbitration in a glocalized world. So therefore, I would not be saying much about the concept of globalized world, its jurisprudence, its political flavor or economic flavor, etc. But at the same time, since I have to give this, my address today in respect of international arbitration in a globalized world, so I'll say something about that and then come back to the topic immediately, keeping in view the time, short time which is at my disposal. We know today that we live in a globalized society, which enables us to traverse space and time, to be informed of global events within seconds, to interact with people in different countries as if they were just next door, and to travel frequently for work or pleasure at an accessible price. In a complex networked world where these borders overlap and interpenetrate, the conventional geographical distinctions between local, national, regional, and global are no longer applicable. Norms, principles, standards, laws, and legal institutions move between national systems and spread from national to a global level and vice versa. The phenomena is sometimes referred to as legal globalization or globalization of law. In the face of social transformation brought about by globalization, law loses its autonomy, and that is very relevant in the context of arbitration, becoming porous and open-ended. Indeed, various legal specializations will be affected differently by globalizations, depending on whether they are already international in nature and if they deal with especially global concerns. In other words, the essential problem is the cultural embedding of the legal domain, or what I shall refer to as the degree of national identity. This traverse of the economic order started with the Industrial Revolution in France, which brought changes in the socio-legal identity of Europe and in the start of 19th century. In Asia, China was the first country to open up its economy, and India followed in 1990s. But when we look at the history, the trade and overlap of multiple normative domains beyond the territorially restricted state, there has been a consistent pattern throughout in every economic revolution. In legal history, particularly, terms like reception, transfer, and transplant have been utilized to describe this entangled procedure. Globalization has led laws and institutions to be transplanted from one national setting to another, exported from domestic law to international law, or to organize directly in the global legal system in recent years. This development, as stated in the beginning, has been termed by the scholars as globalization of law. What is the link between global scripts and local norms in this context when we talk of globalized world? So my aim in this address to demonstrate the two-way interplay between globalism and localism via the evolution of one specific institution, that is the arbitration. I have my address, you will find, I have divided it into three segments, or is contained in three segments. Number one, and when we particularly talk of globalization in arbitration, international arbitration in globalized world, is that historically, what are the institutions or what are the countries where international arbitration developed, thrived, prospered, and the people started looking at those jurisdiction or the institutions, and what are the trends which are now taking place, or what are the events which are taking place where diversification of this is happening. And in future, what would be, that is the first segment where I say, what are going to be the other places of international arbitration. Second is, I would devote some time on we have seen, if I may say so first, in the first instance, we have seen that in international arbitration, the way international legal order in arbitration has developed through some of the well-accepted uniform principles, international practices, and a world legal order which has been developed in glocalized world, and what happened particularly during COVID and after COVID, the way we have changed, and even in the last session when we were discussing about it, that how this legal order in arbitration is going to shape in future. And in the third segment, I would be discussing few aspects in international arbitration, few practices or few phenomena which are shaping up or taking place, how they would be affecting the international arbitration in future. So that is my endeavor. And of course, at the end, I would be just touching upon the two other institutions which are again thriving. In last few years, they have thrived, and how they are going to impact insofar as international arbitration in future is concerned. Coming to the first part, and would not be taking much time, because although my essay which I prepared runs into more than 40 pages, but as I said, I don't have that much time, but I will be giving it to Professor Rajkumar, and he can circulate it to the students later on. As we know that initially what had happened in this context, and we know much of this international arbitration, starting with ICC, not in only ICC Paris, not starting with, I mean, one of the major, ICC, LCIA, in America, many such associations which thrived, and international arbitration became more Western-centric. Of course, in Asia, and particularly if we talk about Asia Pacific, Hong Kong was one such place where international arbitration institution came, which maybe to some extent gave competition to the Western countries, but then again it was developed at a time when it was a colony of Britain and in British style. I'll refer to that in some other context and other study when I come to the second aspect. But we know in last 15, 20 years, Singapore has also come out as an international hub for international arbitrations. And we also know that many countries in Asia, Dubai, even China, India, we have been now taking various steps in this direction. Justice Hemant Gupta is sitting here, and he has been given the charge insofar as making India as hub for international arbitration is concerned. But what I'm only trying to say here is that in future, we do not know whether gravity of center would remain only Western countries, and it is shifting, or this century, as we say, as far as economics is concerned, it belongs to Asia, whether it would be in arbitration as well. Coming to the second aspect, we know actually here that in the context of globalization of law, as the term which I used earlier, the manner in which the jurisprudence has developed in last more than 100 years, and an international order, legal order which has been set up. History thereof, I'm again not going into it, but then in cross-border disputes, international disputes, we need a uniform system so that it is to be, the cases are decided and there are some norms which are adopted are uniform throughout. Of course, some differences would remain because of local conditions, but there have been an attempt by UNCITRAL. There have been various treaties and conventions like Geneva Convention and New York Convention, we know it. And these conventions, when the awards are given, following some international norms, when they come to domestic countries, particular countries for enforcement, the various nations or judiciaries have given their own interpretation. But all said and done, some kind of international legal order has been set up, a kind of jurisprudence has been developed insofar as international arbitration is concerned. Now, the contemporary arbitration is evolving towards greater global synchronization, beginning, as I said, with the New York Convention, the United Nations Commission of International Trade and Model, UNCITRAL, a series of national laws and institutional rules, as well as soft law texts such as International Bar Association rules on the taking of evidence have been combined to form a transnational standard. Many distinct points of convergence exist, including the separability of arbitration agreement, competence principle, as we know, limited remedies against the verdict, and party autonomy. This tendency has been referred to as the foundation of arbitral legal order or the creation of transnational arbitration, as I said earlier. The question is, as I posed, that whether in these conditions, particularly what happened during COVID, and the events of these past years, they suggest an increasing skepticism towards the reaction against rule-based international order. Now, there are some voices which have been raised in the form that has dominated international affairs in recent decades. It can be seen in increasingly illiberal trade policies in preference for unilateral action rather than action through institutions based upon principles. The international commercial dispute resolution system is part of that international order and depends upon that order for continued vitality. The world has been emerging after COVID-19 pandemic is not the same as that which existed before it. It remains to be seen whether the world will include a renewed commitment to rule-based international order when localization in various countries is taking place simultaneously. I feel that so long as international economic activity is there, which would remain and would continue, as it was discussed in the last session also we were hearing, COVID brought about certain aspects which had tendency to go towards localization, but at the same time, there were, when we come to how we fought COVID and the medical community came together, that cooperation is also seen. So therefore, what I feel is that at the same time, in the interest of, and insofar as I said, so long as economic activity remains, which will remain, international arbitration and international legal order has to remain and it would be sustained. Let me tell you here what I said earlier, that look, Hong Kong, which was in Asia particularly, the strongest place for international arbitration, is its place is taken over by Singapore. And what are the reasons? I'm not going into detail, but it's a matter which can be reflected upon. Singapore, if I may say in one line, that Singapore looked towards international institutions, adopted that. All those policies which are good practices in international arbitrations were adopted or have been adopted. And that made it, and some other kinds of development, without dilating it on this, took place insofar as Singapore is, as Hong Kong is concerned. But international order would remain and should remain, but what kind of reforms should be brought there too is a matter which has to be seen and which is a different aspect altogether when we talk of harmonization, etc. Now, we're coming to third segment, and what are the some of the events which are taking place and how they are going to shape the future of arbitration. And for paucity of time, I would only be reflecting on that. But when these are discussed during the panel, when the panel discusses on these aspects, and if I can chip in and I'm allowed by the moderator, I will be able to say something more on that. Now, 5 factors, there are various aspects of various practices which are happening in arbitration. But I will just touch upon 5 or 6 such factors. First is party autonomy, the manner in which it is shaping up. Second is impact of technology on arbitration in post-pandemic globalized world. Third is, of course, related to the second, but role of artificial intelligence in the field of arbitration. Fourth is the confidentiality and transparency in arbitration, that debate which is going on, whether it should be transparent or it should be confidential, and what kind of jurisprudence emerges in future about it. It will have some effect on how the arbitrations are conducted in future. And the fifth is the evolution of global public policy standards. Again, enforcement of the award when it comes to, and what is the public policy, international public policy vis-a-vis public policy of a particular nation where the award is to be enforced. That debate is again still going on, and we have not been able to find a lasting solution to that. So one has to work towards that, otherwise it is going to have one particular way in which the arbitral process would shape up, and how party autonomy would lead to that. Coming to party autonomy, without saying much, I only give you the example of in the Indian context. In earlier, actually, and that is the legal position in early 2000, that if the parties, if it is a domestic arbitration and the 2 parties are Indian parties, you have no right to choose. Yes, party autonomy is there, but domestic law would apply. A phenomenal and significant change has been made by judicial dicta insofar as this party autonomy is concerned, and expanding the contours of party autonomy. And the first such judgment was in 2017, Centro Trade Minerals and Metals versus Hindustan Copper, where the court re-emphasized upon the principle of party autonomy. The court held that the party autonomy is virtually the backbone that permits parties to adopt the foreign seat as the proper arbitration law. In arbitration, the decks have been cleared to give effect to party autonomy by widely accepting it as a guiding spirit. And interestingly, in PASL wind solution, the Supreme Court went one step ahead and said, even if there are two Indian parties in India, if they want to choose not only Kurial law, but even substantive law of another jurisdiction, they are free to do so. So two Indians today can say that we will litigate in America or will litigate in Singapore insofar as arbitration is concerned. Now, how it is going to affect insofar as future arbitration is concerned? In two ways, I would say. Number one, there is going to be a good competition insofar as arbitral institutions worldwide are concerned. Because it is like we had earlier, we were used to talk about medical tourism. So it is going to start now legal tourism. That two persons from India can go to another country and can have their matter litigated, not only in that particular institution in other country, but even the challenge, etc., to that also in other country. Only for enforcement, it comes to India. But that is, in one way, would even give fillip to Indian, when India is trying to become, as I said, hub for international arbitration, because it will go a long way insofar as enforcement is concerned. And particularly along with that Amazon judgment, Amazon versus Future Retail, where in Indian Arbitration Act, there is no provision for emergency arbitration, but still in that judgment, the Supreme Court has held emergency arbitration award to be enforceable under Section 17 of the Arbitration Act. So therefore, it makes the position insofar as India is concerned that, okay, India is enforcement-friendly country, and we are going to enforce the award and the order which was passed in the case in Singapore, SIAC. Coming to impact of technology on arbitration and post-pandemic glocalized, I'm not, because of loss of time, I think I should give to the panel now time to discuss. But then this, I would only say that its impact, now we are talking about the technology, how it is at least the way the arbitrations are going to be conducted with the aid of technology, and much of that would happen. And today, COVID has witnessed, or the world has witnessed because of the COVID, how the not only the arbitration, how courts have been working. And let me tell you only, if I say one word here, from my experience as an international arbitration, that in spite of we going back to normal, the old normal from new normal, still many arbitration are still preferred online or virtual mode, taking advantage of technology. And same thing applies to artificial intelligence. And insofar as artificial intelligence is concerned, there is always a debate as to whether it would supplant the services of the lawyers or arbitrators, or it would be a supplemental thing. My hypothesis, which I have developed over in my paper, is that it is much help can be taken insofar as artificial intelligence is concerned in doing the arbitration in smooth ways. So it is going to play an important role again insofar as future of arbitrations is concerned. And only, let me say only two things more, which I wanted to say at the end, that apart from arbitration, when we talk of international arbitration or even domestic arbitration, there's another mode of dispute resolution which is becoming very popular, that is mediation. And again, in one of my articles I have written, mediation has become savior of legal system and arbitration. It has come to save these two systems. Insofar as legal system is concerned, we say that because, particularly in the context of India, where we are suffering from huge arrears, and if that is taken away from the legal system, most of it, and mediation becomes successful, it would save our legal system. And even in arbitration, there are, I'm not going into those aspects, but then it was conceived as cost effective and time effective, but it is not happening. There are many other ills with which arbitration, international arbitration suffers. And that is why most of the arbitral institutions have introduced mediation into the arbitration to save arbitration, if I may say so. And that is why we have MED, all these systems which are now coming up and where mediation is going a long way. So mediation is going to change the way arbitration, it has already started doing that, but it is going to change the way arbitration would happen in future. Another only one thing, and that is particularly because of in many times and many, on many occasions, although party autonomy is there, but parties file particularly in many complex and big arbitration matters that the arbitral resolution of the arbitral tribunal was not to the satisfaction, many times to both the parties. But then there is no way to challenge that except on jurisdiction and on bias, etc., or fair procedure. You cannot challenge that. And another bite in the cherry is what is wanted in those circumstances. And what is coming? Another institution, that is international commercial courts. How international commercial courts are going to affect the arbitration, that is also again to be seen. And which again, I have said that in my paper, I have written in detail about it, which I'll share. And thank you very much for giving me this opportunity. Let us see how, again, I say that my conclusion is that arbitration is going to survive, going to thrive. All these mediation, international courts of commercial courts and arbitration will have to go hand in hand, and they will go hand in hand and would prosper each other. Thank you very much.
Very good afternoon to everyone. I think we have a tough session ahead, given I have a very tough role to play. I'm coming between lunch and you guys. So it's going to be a difficult one, but I promise we are going to make it as interesting as possible. The first thought that came to my mind is when we had the topic, institutional arbitration, future of disputes in a glocalized world. Institutional arbitration is not new. We have been talking about it for more than 2 decades now. So what new are we going to address in today's session that the audience feels they are going back with something new? I'm not good. The good part is you don't have to hear me today. You have experts from various institutions, and we have Justice Hemant Gupta amongst us, who is going to be the first chairperson of the Indian International Arbitration Center. And I'm going to do a very quick round of introductions before we start off with the questions. I have on my right Justice Hemant Gupta, who is a former judge of the Supreme Court of India. He has started his career in the 1980s, later became the Additional Advocate General of Punjab and Haryana. Thereafter, he moved to the Patna High Court and later as the Chief Justice of the Madhya Pradesh High Court before joining the Supreme Court of India. Post his retirement, he is appointed as the first chairperson of the India International Arbitration Center. Sir has been known for his inclination towards a digitalized world. He has played a very key role during his tenure at the Punjab and Haryana High Court for the entire e-filing system and the digitization of the court records, which I'm sure is going to be very handy for the India International Arbitration Center. On my left are two beautiful ladies, Shweta Bidhuri, who is the SIAC person representing SIAC before us in this panel. She started her career in 2007 as a lawyer and was working with one of the leading law firms in Delhi prior to moving to SIAC. At SIAC, she is responsible for administering the cases and heads the South Asia sector. On my extreme left is Sherina. Sherina is a partner for Norton Rose. She also plays a very important role when it comes to the LCIA. She has been on the board for 2015 onwards and has seen the transformation that has happened in the organization, with whether it be the coming into age, adjusting with the new world, the digitization. So I'm sure with such a rich and enriching panel, we have a lot to discuss and for you to take back. I'm going to start my first question with Justice Hemant Gupta today. Sir, the India International Arbitration Center is considered an institution of national importance. It's been come up with the idea that we are going to promote India as a hub for arbitration, have more efficiency in place, ensure we have ADR and an own Indian arbitration institution which will promote India and our approach towards arbitration. It's a fairly new institution. It's hardly been few months. So I understand, like most institutions, it is going to take its time. But what are your views and what is it so different that this institution is going to do? How do you think it's going to take its first steps as to ensure it comes at par with various other global institutions?
Thank you, Payal. You are right, India is should be hub for international arbitration. I'm told there are about 35 institutes in India which are working towards the international or domestic arbitration. But this India International Arbitration Center is the only center enacted by an act of parliament and declared to be an institute of national importance. The issue is India is still governed by ad hoc arbitration. The court appoints the arbitrator, which the particular judge feels is a suitable arbitrator. But the institutional appointment of arbitrator is still a far dream. The difficulty is the general argument in favor of ad hoc arbitration is that it's less expensive, it is efficient. But all these concepts, all these principles are short-lived. Ad hoc arbitration is where the parties choose or the court appoints an arbitrator. There is no control over the sittings. There are instances when the ad hoc arbitrator has held the sitting twice a day, before noon and afternoon. And that has brought bad name to the institution of arbitration. I remember a matter which came up before me when I was in Chandigarh, Punjab and Haryana High Court, where the parties have paid rupees probably 80 lakhs as fee to the arbitrators and still the issues were not framed. The government organization was one of the respondents. So they came with an application before the High Court to terminate the mandate of arbitral tribunal. So I decided that it requires consideration, but the order passed was challenged before the Supreme Court. And in Supreme Court, instead of arbitral tribunal, sole arbitrator was appointed. The issue, what I want to say is that ad hoc arbitral tribunals don't inspire confidence because there is no control over them. They are master of their own board. They fix their hearing, they fix their tenure, the timeline. But in an institution, there will be a fixed fee. There will be a timeline during which the arbitration has to be completed. It's going to be better controlled, better regulated arbitration. Coming to the next part of the question, that how we are going to be different. India is a vast country. In one of the conferences last week in Delhi, arbitration weekend, one of the participants from Bombay asked me a question, are we competing with each other? I said, no. We are complementing each other in this field of arbitration. As India, we owe a responsibility to the country to bring India on the international horizon to as an international hub. That is our mandate. Not we don't want to compete with each other. We want to propagate India as the arbitration hub rather than a particular center in Mumbai, Hyderabad, Delhi, or anywhere else. India should grow. Why Indian parties should resolve to have their disputes from any other arbitration center. We have best of the lawyers, we have best of infrastructure, but the delay which happens after the award is one which deters the litigants to resort to the different arbitration jurisdictions. So, as Payal has said, that is a new institution. We are in the process of framing regulations. One regulation which we have framed is how to impanel arbitrators. It should be published by this next weekend. It is all ready. Then next is the conduct of arbitration proceedings. It is in the process. We are discussing within the center. After that, we'll put to those regulations for public discussion. We'll take inputs from the in-house general counsels, from the arbitrators, and from all stakeholders that how can we improve those regulations, which is to the satisfaction of all concerned. I think that is our vision. That's how we want to work ahead.
Thank you so much, sir. I'm going to move to Sherina quickly. Sherina, as I said in your introduction, you've been on the board of LCIA. We have heard the chairperson of a new Indian institution which is coming into place. LCIA has been there for a very long time. LCIA had its offices in India also, which were shut a few years back. It came back, y'all had a couple of road shows in the last month. However, from the outside, it seems that the focus seems to always be on London or Europe. So do you feel that there is a need that you have to have a focus on the other jurisdictions? I don't mean to say that Indian parties are not looking at LCIA. LCIA still serves as a very good institution which resolves disputes involving Indian parties, administering it from London. And you have seen the change happening in the institution over the 2 decades. So what is it that needs to be done different, or what is it LCIA is doing towards its focus on other jurisdictions?
Thanks, Payal. I know that it seems that because the LCIA is the London Court of International Arbitration, and it has that word London in it, it's very London-centric, and that is the perception. Unfortunately, that perception isn't really true. And when we were discussing this before the panel, I actually looked at some statistics. In 2020, only 13.4% of the parties were actually from the UK. And 2021, only 14.8% were from the UK. Europe is different. In 2020 and 2021, it was about 26%. And when you look at Asia, the percentage was 9.2 in 2020 and 8.1 in 2021. Now, what I do agree with you is about India and that it fell off the bandwagon, because I think when I started practicing, which was in about 99, 2000, a lot of the clauses that I would look at were LCIA clauses and ICC clauses. And that seems to have dropped off the bandwagon because there's only, I think, a meager 1.6% in 2020 from India and 2.4% in 2021. So those statistics speak for themselves when we're looking at, say, the past 20 years and today. And that's obviously because of the rise of SIAC and ICC, etc. But holistically, when you look at it, actually, and you look across the world, you're looking at less than, over 80% are from outside the UK, and over, and over 60% are from outside Europe. So those are quite telling statistics, I would think.
Actually, when you look down and see the statistics, it gives you a completely different picture. And often we are led by a perception based on which choices are made, but the reality is quite different. Uh, Given I also have Shweta with me, I'm going to not ask a very traditional institutional related question to her, but more with what we have been witnessing for the last 2.5 years. With the onset of COVID and everything moving virtual, I think every institution geared itself up to be at par with various technologies to ensure that they provide virtual hearings, there is a proper digital mode of filing in place, and I know SIAC has come up with various initiatives to ensure and be as agile and as much as possible be there for the users at to round the clock to ensure there is no gap just because they're not there physically. So given this situation, and now we are moving slightly towards a post-COVID era, Shweta, do you see a change in the mindset where we are okay with a hybrid model of going ahead with hearings and procedures, or users want to go back to the old traditional model of a physical hearing, or is there a resistance and people are okay, now it's virtual is the new normal, so we don't need to go back and, travel, spend some time, cost. What is the change you have witnessed?
So I think when the pandemic hit and we all quickly hurdled up to see what are the changes and how does SIAC respond to the needs of the users. Justice Sikri mentioned that virtual hearings have always been part of arbitration. We always had cases where there have been some element of whether you had somebody joining virtually or the procedure hearings taking place on teleconferences. But it all augmented during the pandemic. And which is when SIAC also looked at, we started this live Q&A on our website, which is also important to have, this connect with the users where they could, on a real-time basis, reach out to SIAC and understand, okay, in this new changed reality, how can the arbitrations be conducted? What would it impact on the clauses, on the way the procedures are being done? And then, SIAC also issued a checklist to help parties navigate these challenges that they may have had. I think initially we all thought, there will be a dramatic change in the way arbitrations are being conducted. Of course, we had some learnings from the virtual hearings, how much more it could be integrated. People became, I think, more easy with using technology. It became so much part of our system. But really, post-COVID, if I can say post-COVID, hoping that there is no other variant in the horizon, we've seen a mix. Some hearings, of course, I think for procedural hearings, it's pretty much the default to have it being conducted virtually. But so far as the substantive hearings are concerned, we're seeing a mix on the trend. I looked at some statistics this morning and said, okay, let me figure out where does it really stand. Are there cases which are being conducted fully virtually? And the cases were really from either the cases which were under expedited procedure or smaller value claims, some of which were conducted fully virtually, even in a post-COVID world. But where there were higher claim matters, there were fewer in number. But there was some sort of hybrid element in it, which I think also was helpful to avoid disruptions. So if you couldn't have someone being able to join arbitration, that didn't mean that you will sort of postpone the arbitration to another date. It just simply meant that that person will join virtually. But the hearings, to larger extent, where the merits and all of that were being involved, were being conducted in person. So I think 50-50 on a general basis. So we haven't really either gone back to how we were doing it or followed the model of COVID. But it has certainly brought about greater efficiency with the use of technology. Of course, the filings have moved online. We are internally also at what I call the SIC laboratory discussing how much more technology can be used to facilitate and help the users get their experience more efficient. So yeah, some of those things have definitely played out even the post-COVID.
Thank you, Shweta. Actually, given my own personal experience as an in-house counsel, I think somewhere I would relate to the 50-50 statistics because everyone is quite comfortable with a procedural hearing being virtual or we don't even need to be physically present in one room for that. But often and not, what happens is when we have complicated, complex arbitrations which are very document heavy or which have involved a lot of evidence which needs to be looked at times when you're conducting your cross-examinations, you do prefer to be in the same room because you want to witness the body language, how the tribunal is reacting to it, how the witness is responding. So yes, there is no right answer, I would say, but what works best in a given situation, in a given matter, and how best you address that particular dispute. Moving slightly from the institutions and the kind of arbitrations or processes which are in place, I can't resist myself from asking Justice Sikri, given we have him today along with us in the panel as well. So you have been a former judge of the Supreme Court of India, delivering landmark judgments on arbitrations, commercial laws, intellectual properties. Today you are an international judge on the Singapore International Commercial Court. You see a lot of disputes which come over there, but Singapore has a general, it's known for the fact that there are not too many applications or petitions being filed where arbitration awards are actually being stayed. There is a lot of scrutiny that takes place. Singapore is obviously developed as a hub for arbitration across the various jurisdictions, and it's known, recognized in Asia for that. Given your experience as a judge here and a judge there now, sir, obviously, institutional arbitration gets its support from the judiciary as well. Whether it's a positive approach towards it, is there a difference in, sir, the advocacy itself or the approach itself across jurisdictions, which actually show that there's a difference in how arbitration is treated and, more importantly, how institutional arbitration is looked at?
Actually, very relevant and very important question which you have put. Let me tell you first, as Justice Hemant Gupta also mentioned about that, if we talk about the talent of judges in India, we talk about the talent of advocates in India, I will say that it is no less, correct? And thing is that same thing, of course, I have seen in last 4 years now in Singapore, the way judges are chosen or they are appointed. Not only I am talking of international judges in SICC, but I have seen now their system as well in Singapore courts, right from whether it is judicial commissioners or High Court or Supreme Court, Court of Appeal, which they call. It is one thing which I admire is totally 100% on merits. There's no other thing. And all those who are there in the Supreme Court or in the judicial system in Singapore, there's a pool of talent. And likewise, I would say SIAC also, when it empanels the arbitrators, they go by merit. Of course, there may be other, to say it lightly, other professional or economic considerations as well, because they want business as far as SIAC is concerned. But by and large, it is on merits. And advocates there are also, some of the advocates are really outstanding. There's no doubt about it, who have appeared before me in SICC and few SIAC arbitrations which I have conducted. So therefore, but the difference lies in approach, in the mindset, and the exposure, if I may say so. Because when there are cases coming up in SIAC, yeah, that is arbitration, or SICC, from all over, the issues, they are really complex, commercial issues. and the way they are argued. As I said, the issues which are coming up, they are like in any other Western countries, those kinds of issues. Some of the issues which, although I have been judge for 20 years, I practiced also before that on commercial sites, I may not have come across those kinds of issues in India. India is also now, at least when it comes to enforcement, and these awards which come from, like I gave the example of SIAC emergency arbitration in Amazon case. So we are now confronted with these issues, our judiciary as well. And in course of time, I think, and particularly I see today in our Delhi High Court, some of the judges on commercial, and the kind of commercial exposure which they are having to commercial litigation and commercial law, we may be able to catch up with Singapore in due course of time, but they have, maybe it was because of these kinds of exposure there, and they were ahead of us in time. And that is the difference which I feel.
So we still have hope, and India has a long way to go, but we are going to be there, for sure. Sir, given you spoke about the complexity of the disputes which you are seeing at SICC, I think moving on to Shweta, the arbitration is no longer simple contractual commercial disputes anymore. There are various facets to an arbitration today. It could be something which is focused on oil and gas. It could be a construction arbitration. It could be a maritime arbitration. So it's not just pure play arbitration in place. There is a need for a sector or an industry focus which is required today. I believe SIAC does have several courses in place and an academy which looks at these specific areas. So is there something specific we can expect from SIAC in coming times, where we can understand that it's not just about administering an arbitration, the procedure itself, but the institution is looking at having arbitrators, tribunal secretaries who understand the subject, the industry, and then how it translates when it comes to an arbitration in that particular area?
I think I'll borrow from what Justice Sundaresh Menon once said, that the role of arbitral institution is no longer about just being a gatekeeper. There is, of course, the thought leadership. Also be mindfully aware of the needs for which the institutions exist. SIC is a service provider, of course. But, I mean, so far as the sectors go, it's always been the case. I mean, of course, you've had trade-related disputes, corporate-related disputes, oil and gas, energy, infra, construction, always been there. And, the idea was to constantly look to widen the pool of arbitrators who will be able to understand the nuances in each of these sectors. Which I think why in the first place you have arbitration, because you're looking at expert deciders. We, from the panel of arbitrators that SIC maintains, we also have the IP panel, which is separate. We're also considering to have more sector-specific, within the panel that sort of divide and identification. We also, constantly on the lookout to identify arbitrators with that. I mean, we have more, I think, interesting disputes come up with crypto, fintech, which are highly specialized. While you may have arbitrators who are excellent on procedures and law, but in terms of understanding these industries, there is a greater need to create that pool to identify those people being able to slot, and which I think comes back to the value of the institution to be able to appoint the right arbitrator on your case, which I think, Justice Gupta talked about why institutions and between ad hoc and the institutional arbitration. But really, I think the crux and the heart of an institution lies in being able to appoint the most suitable arbitrator on your case. So the job, and I think those antennas to be up and identify even amongst the practitioners. So when we look at people arguing on a case and we know that this person is excellent on crypto understanding and how he might be suited to either be on our reserve panel, which is a panel that we maintain from our own list that we quite often use to appoint on different cases, who may not be on the publicly available panel as well. But so that exercise is, is one part of identifying the arbitrators. The other is the role of the thought leadership and also the responsibility of the institution to train people. So SIC runs a vertical within its own strategy and development for academy. So we're now running specialized academy, including for investment treaty arbitrations, for construction related, and also for fintech related disputes. So we're constantly evolving on that to understand the changes in the types of disputes. I think that's becoming quite interesting to watch. It's no longer atypical type of dispute. You have so many nuances and layers within a dispute itself. But to cater to that, of course, that training is important. Also the tribunal secretaries. So we're also considering a program specifically for tribunal secretaries, who can be appointed from the secretariat as well. So yeah, so different measures that needs to be, of course, because otherwise we would not be able to serve what we meant for.
I think Shweta touched upon two interesting aspects. We need to move with time, and the need for having arbitrators who are experts in certain fields itself. Now, the Indian Arbitration Act, with the amendments which we have seen in the last decade, we came up with the Arbitration Council of India. What was the purpose of that? For the accreditation of panel for various institutions, for grading of various arbitral institutions, for empanelment of arbitrators. Which brings me to the question to Justice Gupta. I understand IIAC is a new institution, but what are the steps or what is the thought process the institution has in place for empanelment of arbitrators? What is the criteria that is going to be followed? How would you go about that entire process itself?
Section 28 of India International Arbitration Center Act provides for Chamber of Arbitration. The Chamber of Arbitration is to consist of known national and international arbitrators. They, in turn, would impanel arbitrators. So there's a specialized specialized persons who will be member of the Chamber of Arbitration, and they will in turn impanel. The rules which I talked about the how to impanel, that has been finalized. It has been sent to the government because it has to be gazetted. It will be gazetted by in the next week. So obviously, one has to be expert, one has to have the integrity, one has to be, whatever the reputation. The reputation travels faster than the man. The reputation of the person would be the relevant factor, whether the man is of integrity, whether he can deliver. All these things will be considered by the Chamber of Arbitrators. What we are trying to do is there will be one section, one part would be dealing with the domestic arbitration, to impanel domestic arbitrators, and one for the international arbitrators. So there is expertise available to choose the person from the respective fields.
Thank you so much, sir. I know we are running late and we just have a couple of minutes. So the last question would be to Sherina. And it's going to be not just an institutional question. I think it's a much bigger issue which we want to address over here. Obviously, one of the aspects which Justice Gupta just mentioned about empanelment, that's also something I want you to touch upon, how LCIA goes about with the entire appointment process. But I think a bigger issue is how are we going to address that there is more gender and geographical diversity as well when it comes to having more women arbitrators. And yes, I'm going to be a little biased. I want to see more women arbitrators from India itself. We need to have a bigger pool in place. And I would request all the other panelists after Sherina to address and give their views as well on this issue.
Thanks, Payal. So diversity, according to me, is essential for the longevity of arbitration. But it also helps with the quality of arbitration as well, because you're hearing different views from different parts of the community. Now, in 2015, 2016, the LCIA recognized that there were different types of diversity, which included age, nationality, and disability. But it actually first decided to pick up on the lowest hanging fruit, which was gender diversity, because 50% of the world's population are female. Jackie Van Hoff, who was the Director General of the LCIA, actually was one of the pioneers and the inspirations behind the pledge for equal representation of women in arbitration that launched in 2015. And this was actually awarded the best development of arbitration at the Global Arbitration Review Awards in 2017. Now, what is the pledge? The pledge has two objectives. One is for increasing the profile of women in international arbitration, and two is for the increase of appointment of women in international arbitration, so that there will be ultimate gender parity. And the practice tabulates very concrete steps that people can look at and action to go with the objectives of the pledge. I'm on the Global Steering Committee of the pledge, and I also chair the India Committee. The pledge today has 5,000 signatories around the world, and it has single-handedly led to the huge increase of the number of women in the world from arbitral institutions being appointed. Less so, although there is a lot more, I would say, knowledge, but less so from the parties and the co-arbitrators. But really, it is the institutions like the ICC, SIAC, and the LCIA that are leading the way. In terms of numbers, the LCIA in 2021 reported that 45% of the people appointed by the LCIA were actually women. And you compare that to 33% that were appointed by parties or by co-arbitrators. Practically speaking, what do I do as a partner at one of the large global law firms? When I get a list from co-arbitrators, which is a list of all men, and that's not just me, all my partners in the firm do it, we push back and we ask the co-arbitrators to reconsider that list of chair, and we ask them to give us a more gender-neutral list of, say, 3 women and 3 men to consider. And we don't do it because we just want to see women there. We do it because women are as good or better than men. I do the same when I sit as an arbitrator as well. And I usually have a list of 3 men and 3 women and let the best person win. But it's the thought that goes behind it. It's the thought of putting the women out there. And if we don't do it, no one else is going to do it. Well, the institutions are doing it, but we need to do it more. In relation to India, I launched the pledge in 2018, actually on a platform provided by the LCIA, and today we have a group of 120 women that support each other. There's a WhatsApp group where lots of questions get asked. Women have appointed women through the group as arbitrators, as counsel, as experts, and lots of friendships have happened through the group, and the group is growing. When I started it was 10 women. It's 120 today. And we hold lots of sessions. We did lots of knowledge sessions during the pandemic when everyone was bored and looking at their screens. And we invited trailblazers, women. We gave access to the women of India, to international women, to find out how difficult were their journeys, so that it inspired women that all of us have faced a very difficult journey, but some of us have made it, and they can make it as well. And the next step was actually earlier in February, again on an LCIA platform, I launched the India Promise, which is for the representation and the equal representation of Indians in international arbitration. And I hope that we will be seeing much more Indians on the international scene, We're as good, as Justice Sikri said, we're as good as the international lot. We just need to be seen more.
Thank you so much, Sherina. It gives us a lot of hope to all of us who are in this fraternity, and we know that there's a lot of encouragement coming in, and there is a day where we will see a lot more women arbitrators in our country. Justice Sikri, if you could have a last few words from you.
To tell you, and when it comes to gender, diversity, on my retirement farewell speech, I advocated for feminism in judicial decision making, and which is very, very important. I've always felt that women are no less as compared to men, and therefore it is needed. Two examples, if I give, and one is LCIA, other is ICC. In one of the cases in LCIA, the arbitration clause was such that the entire tribunal was to be constituted by LCIA. It's not that the parties will nominate their nominee arbitrators, and then nominee arbitrators would be appointing the chair. One party is Indian in that case, and one party is from US. Of course, LCIA has said that they must have thought of neutral jurisdiction, so LCIA was in the arbitration clause. And LCIA nominated me from India, one senior counsel from US, and since chair had to be from a neutral country, from London, and a woman. So I really admired. I've been working in that case with that woman, and she is really very, very good. Another example of ICC. Here, two of us had been again, I am a nominee arbitrator, but the party appointed nominee arbitrator. But the arbitration clause said that ICC will appoint the chair. And ICC, with two of us are males, and ICC again appointed a female. She is from Paris. And we have already given about 2 weeks ago, only the award is also given. And of course, it's given to ICC, which will be editing and doing other things in behalf of that. But I'm saying that in respect of this too, it shows that international institutions, arbitral institutions, are working towards gender neutrality. Coming to geographical diversification, I only remember, and as you have, of course, Sherina has mentioned about taking more and more persons from India, but Justice Raja, V.K. Raja from Singapore, this ex-judge, who said in one of the interviews which I read about SIAC, I don't know, you have to take in, it may sound to be somewhat personally interested in that, but he said that 55 to 60% cases are from India, and the arbitrators appointed from India are only 7 to 8%. So SIAC has to look into it. Thank you.
Just quickly answer to Justice Sikri. I think we are a victim of our own cause, because most international cases with an Indian counterparty, then we tend to have to look for a neutral arbitrator. And that's why it becomes difficult to have an Indian arbitrator on those cases.
Thank you so much, everyone, for your patience and being there with us on a Sunday morning. Thanks a lot to all my fellow panelists for an excellent session. Thank you.